Very compilation.
Please. My lord, can I just make one suggestion for everyone here? My lord, as per your lordship's order of 15th January 26, your lordship at para 3 observed as follows, that prima facie eligibility condition must be uniform. So that should be, my lord, in with my respectful submission, the focus of the argument before your lordships at this stage, because it's not that we are reopening the whole thing. Yes.
Uniform also
And holistic.
trying to read the pulse of the NLU students.
Yes, my lord.
From the country.
My lord, actually only 2 NLUs have responded. I wish some more would also.
To say, my lords, and what my friend is saying, my lords, and what we are insisting, my lords, on your lordships considering the following, my lords. One, my lords, is not only what the high courts may have expressed, because there is extreme divergence even amongst what the high courts have expressed. We do respect to, my lords, the views of the high court. Some kind of objective criteria is needed, my lords, for this purpose. Not only the desire, but, my lords, also the need. Secondly, my lords, your lordship is constantly encouraging the judicial academies, which are undergoing these training processes and have been set up, partly for this process of training itself at all levels, then to encourage yet another tier, to actually stagger the difference between the entry levels and the promotional levels. Because you're going to discourage a number of people. Because by the time they will achieve after adding in these years of training as a necessary prerequisite, it will go from 27 roughly at the entry level with the 3 years training to 41 to the next level, which will discourage not only people and youngsters from going into this field, as also women. Because women have separate constraints, and our lordships have noticed that in various other issues, matrimony, etc.
There is no question of going to 41. Because 27 now there is 3. Fast track promotions are there. There is no question of waiting till 41 and all that. That was probably at the earlier point. Now it is.
50% still go by promotion.
No. 30 promotions. Fast track
promotion part we are not worried. Promotion part, the avenues have become slightly better.
That your lordship.
No, I'm not saying it hasn't. I'm saying the time gap.
Judgment has built on that in great detail.
What is our worry is that probably one thing which that might require to be revisited or reconsidered, that if this condition have been applied immediately or it should have been applied from a date in future. What is happening is today.
We have invested. The students have invested.
16th convocation I have done in a couple of months, and it was with a purpose, not that I only invited and went there.
We have 2 submissions.
There are issues which the young, very bright students are raising. Problem is that now, as on date, now you advertise throughout the country, you don't have any young pass out who is eligible to compete. Who are those who have been last 5 year selection processes rejected consistently.
Or those who have practiced for 3 years.
This is what I'm saying. Those who have already tried their luck, not selected, but continued in profession, now they have become eligible. Only the competition will now on all India, competition will be confined between them only. The new grad, the bright students coming from NLUs, etc., they are in default now. They are not in a position.
That's right.
If I may.
I said it's a balancing between these rights and also what our constitutional high courts also feel should be the correct.
The best of the time.
Absolutely.
With the lordship's permission, may I submit 2 submissions?
Talent shouldn't go. They've taken loans, they've invested in time, prepared. What about the current exams? For example, the people who've come out currently or the last year or the year before, with the expectation that they'll be giving it for the exams. We are turning the rules of the game mid-level. And
with your lordship's
frowned upon by your lordships in every situation. Bihar has come out to the advertisement.
With your lordship's permission, may I have 2 submissions to make?
Yes, sir.
So do it in phase manner. Say, for example, first it can be 1 year, then 2 years, then 3 years, because by the time batches will start.
So that will be a tweaking of the condition, or that's right. Very, very well.
Lordship, if I may.
Same, how to
balance it out, yes.
Apply it, that's all.
So, my lord, may I just, what your lordship said,
give
that.
We increase the training in the judicial academies, my lords, by another year. There's already 1 year provided for. Instead of providing 2 different tiers, my lords, which is there, my lords.
No, academy problem is in academy that kind of practical training which you get when you as a junior counsel, you go to court.
In internships in college, my lords, yesterday in our times, my lords, there was nothing.
Real-time court experience may not be available in the academy.
Because it is mostly.
Sometimes.
The lordship is
but there are other way out. Yes. The other way out is that compulsory internship in the offices of the lawyers only.
It is
that for 6 months you do in district court lawyer, 6 months you do with the high court lawyer. That should be a part of compulsory curriculum. in the law school itself.
That could be done, my lords.
That can be.
That is
Lordship,
something that
this
the lordship
clarification that was filed, it was
Let us
ready.
consider these things.
My lord, may I just file that submission? before your
Lordship,
lordship?
a minor
I'm unable to
clarification.
your lordship.
It was brought in, this 1 year compulsory, my lords, training even before enrollment was brought in 90s, if your lordship would recall, my lords. Ultimately, it was set aside on technical grounds of authority, etc. My lords. But this 6 months, my lords, in district court, 6 months in high courts. In fact, we people didn't have the pressure, my lords, of internships. We came straight to the profession and learned the hard way up. But neither is it made today. Students are having compulsory 12 months. If it could be split up into a logical solution, my lords, of practicality, because ultimately what has come out in all these high courts, my lords, is to say this: demeanor, behavior, practical difficulty, because that they have to, my lords, this has to, the training has to come elsewhere also. It will not only be through practice, my lords, it's standing in court, with due respect, my lords.
Some of
With
the high
lordship,
courts
some
have said that
kind permission, may I
matters of
make-
life and liberty are being dealt with. So high courts have their own views, so I'll put it all across. You know, just one request, your lordships will just give us one more opportunity to whichever high court has not filed, which they want to file, and any NLU wants to file, so that holistically everything is before your lordship.
Now, this view,
Your lordship.
report is probably a misnomer. We should have taken the viewpoint of the Chief Justice.
Sorry, my lord?
We should ask for the opinion of the Chief Justice. There is a difference between High Court and.
Very well, my lord, that's very good.
They have-
But-
Right.
There are issues.
Your Lordship.
With your kind permission, your lordship.
Example, means Bihar has come out with the advertisement in 26th of February.
With your lordship
Mention,
permission,
your lordship.
we kindly,
Because what will happen to that, because in the immediate, my lords?
With-
That advertisement is already out. When it will be held, my lords, I don't know.
with your kind permission, your lordships, we would like to be the petitioner in the 301, we'd like to submit to things in the matters, your lordships.
Build category.
That's another category, yes.
There was already a
So, not there, what happened was that that judgment came in the interregnum between this judgment being reserved and this judgment being pronounced. So, the three judgment was reserved on 28th of January 25, and before it was pronounced in May, that judgment came. So, none of us addressed your lordships on that issue.
Your lordships,
Otherwise, we would have.
your lordship, the judgment in 302 anyhow becomes per incurium, as per the judgment of this judgment of the 3rd of March, your lordships.
wait, please.
Your Lordship,
Hard eating arguments can come later on. We are trying to resolve an issue.
Your Lordship, there is a peculiarity in one of the IA. Your Lordship, there is a peculiarity in one of the IA, that is 336091. I am a second year law LLM student of Delhi University. And there the condition has been mentioned that I have to file an affidavit that I am not doing practice. And that affidavit is mandatory for doing the LLM course. Now, Your Lordship, I have taken admission pre-judgment. 2 years already spent. Now I have to spend 3 more years. That is, I have to spend 5 years. So, Lordship, number of states are advertising now, and I will be debarred, Your Lordship.
There are complications.
Yes.
You please share with it with Mr.
I've got it, my lord. I've got this.
Number of difficulties currently. Because the law commissions have come out with several reports on this.
So, Your Lordship, there is a immediate attention is required so far.
Some of the issues which will require some,
Right, my
we
lord,
need
right.
to iron out some creases.
Yes, my lord. I'll make out
I
and
mentioned,
circulate it to everybody so that it's not adversarial at all over here. Everyone-
I mentioned 301.3.
The most difficult situation is to face the young girls when you go to NLU.
Right, my lord.
And I have, because I have been confronted, that's why
No, your lordship, sir.
the girls are really, they are shaken.
You know, there is actually a class advantage difference and a gender issue, my lords, here also involved because of
Lordship.
circumstances. And we can't ignore that, my lords. Your lordship is absolutely right. But, my lords, in the meantime, while your
But
lordship
with
is
the increased percentage, now that we have almost reached 60%,
Right.
the women judicial officers. So the girls are our potential material on merit.
Of course, my lord, no one is.
And if they are, because of this condition, the fear is that they will never be able to compete because the families will not allow to go to them.
That's right.
They will be forced, get married and settled here and there. So these are these are a new type of.
One
challenge
writ petition is on
which
the
are-
ground itself,
which
that
are,
your lordship.
you know, more of the social issues instead of the eligibility issues alone.
No, the idea was, my lord, that whatever ultimately your lordship devise is something holistic so that then it can work for everybody and not that, my lord, every 6 months someone has to come and ask for a modification. So I'll make it in that particular light so that everyone can.
Lordship, in
Can we, I mean, we have to improve there is no doubt about it. And
Right.
practice is a very important component of
Yes.
judicial services. But how to introduce it in such a manner that it does not deprive us from consideration of the meritorious candidates.
I understand.
And it does not create a vacuum of 2-3 years.
and young talent.
Because 3 years vacuum if it is created.
yes.
Situation is like this now. that if you go for recruitment today, you do not have any fresh pass out eligible.
The fresh pass out of today not
So
eligible.
who are the only candidate who have competed already, tried their luck, not selected during last year?
Or those people who did not try their luck but now want to try their luck
Most
after
of them
having.
tried their luck because
Right.
now those will be trying only, either they didn't try or they tried and failed. Now only they are the eligible
No,
candidates.
we'll put it before your lordships in that manner so that your lordships can devolve.
But
it.
we'll take
lordship
we consider
should
for
also be-
example, Bihar,
Interim करता हूँ.
instances
lordship-
like where they're coming up, Lord, something has to be done. It can't go for a consideration because
Your lord-
they'll be denied outright.
We will.
Your lordship should also consider that the process,
It's released its advertisement on 26th of February, my lords, for the exam.
Has to go on. to-
Immediate examinations are there, Your Lordship, and
Lordship.
ultimately will not be able to even apply. That's the
Your
difficult.
lordship, we,
Exams are where?
Exams for the competitive examinations now Delhi and Bihar. So immediate requirement is there, 3 years requirement is there. And now I am already barred because of the affidavit condition. I have to spend 5 years now. And at that time, before that, I was eligible because I am already passed out. And I will be losing number of attempts also, Your Lordship. I will be completing my 28 years, up to 32 in a number of states. In majority of the states, the age criteria is maximum 32 years, barring few states like there is 35 years. So if supposingly, Your Lordship, there is a peculiar condition. In 4 years, just 1 or 2 advertisements come in, or one single advertisement is there, I'll getting a one chance only. So getting a chance by a meritorious candidates who are pursuing higher qualification will be discredit to them. They will not be having an ample number of opportunities to appear, Your Lordship. So that is an absolute peculiarity which has come up.
This actually might be a Delhi specific.
Delhi is specific, and we are the
Only
meritorious.
Delhi University is saying that for LLM course you can't practice.
Yes.
Bar Council of India has said that while you're doing an LLM you can practice. But Delhi University has, so this is not an all India problem that my learned friend has. This is a Delhi specific problem.
And Your Lordship, there is a judgment to that effect also. Honorable Division Bench of Delhi High Court has already categorically held that Resolution 96 of the Bar Council of India that permits that LLM is not a bar at all. So the Delhi University's curriculum, their rules and regulations and their resolutions are contrary to the resolution passed by the Bar Council of India.
You have to address that before the High Court.
He has approached High Court.
I approached the High Court,
Yes,
then Honorable High Court said, all right, this remedy is not available to us. So that's why I take a liberty that in the meantime, I'll approach the Honorable Supreme Court.
lordship,
So they're not considering, Your Lordship, frankly speaking, we have to withdraw the petition from there.
Vacancies
your
Bihar.
lordships, we just
Advertisement.
request for,
173 vacancies, Bihar has come out with the advertisement clause on 26th.
lordship
your lordships, we are.
also has to consider the process in itself.
In the opening, we'll keep it and.
Very well.
You.
With your lordship's permission.
I'm sorry, my lord.
You do it in two.
We'll do it in this next week whenever your lordship after that wants, whichever convenient.
Lordship.
Do it.
Lordship, there's this
Lordship,
IA
Your Lordship, I am seeking to mention 301.3. Your Lordship, this is wrongly tagged because the 301.3 issue is different, Your Lordship. 301.3, that is a writ petition, and 3rd February, it was listed, Your Lordship, directed to me to amend the petition. I have made all state bar councils party. There is a, Your Lordship, issue is registration of the advocates. Therefore, Your Lordship, this matter will maybe be de-tag, Your Lordship.
Bar Council. Madam, why you are taking 6 months in issuing registration?
Your Lordship, I will, he may supply a copy to me. It cannot be 6 months. I will have it.
Get the instruction.
I will get it.
Declare that once a candidate apply, and if you fail to grant him license in 3 months, then he will be deemed to have been authorized.
Your Lordship, it will not be 6 months. I will check. I will check.
My
A copy
registration
will be
has done-
supplied to me, Your Lordship.
My self-registration taken 6 months, more than 6 months.
No, Bar Council.
It would be the
Uttar
state
Pradesh,
bar
you are not-
council.
Bar
which is
Council of
enrolling,
Uttar Pradesh.
But I will find out from.
Bar
the
Council of
state
Uttar Pradesh,
bar
my lord.
council.
Bar Council.
See, I'll find out from the state.
You
bar
have to
council.
issue a policy circular
I
from
will.
your side that every state bar council will ensure that within 3 months maximum.
Then your,
Inquiry, etc. is to be done. It must be done, and within 3 months the license must be issued. Otherwise, we will pass a judicial order that they will be deemed to be eligible for the purpose of.
I'm sure there's already a policy, Your Lordship. I'll place it. I'll just take the papers.
Lordship,
your Lordship,
may
my
I
request,
mention an
my
IA? It
humble
was
request,
ready
my
for
lord,
listing in
this
October.
may be de-tag, Your Lordship. Because issue is different, Your Lordship. My request is de-tag this matter.
It is,
Tag or tag, we will, on that day you got it tagged, now you said be tagged.
No, Lordship, I have not requested, Your Lordship. for the tagging.
Which is your item?
Tagging 301.3, Your Lordship.
You list before the regular bench.
Please.
Your Lordship,
Lord-
we have two things.
May I, my lord, mention a matter to be put along with this batch, filed last year. In July last.
Similarly, Lordship, there's another IA. It was ready for listing in October last year. It has still not come up on the,
Well, give us the particulars, we'll see.
Your Lordships,
Take up on the opening week, so.
Lordship,
Your Lordship,
In
please
the
see-
meantime, if your lordship just
intervention,
don't mind saying
Lordships.
that let whichever high court still wants to file, Chief Justice, they can do it so that it's all.
Super, in reference to the
Please.
order dated so and so, some of the high courts have, most of the high courts have sent their opinion.
With your
That's
Lordship's
opinion.
permission.
Our
Madam?
two high
With
courts.
your Lordship's permission.
Highlighted one.
With the Lordship's permission, we just have two things to
The secretary-
Lordship's submit.
The discharge journals of the remaining high courts, of the left of high courts, giving last opportunity to submit their review point by 9th March 2026.
Please.
Post this matter on so and so date after 1 or 2 days at 2 p.m.
Lordship, may kind
Lordships, we have two submissions to make. Your
notice in the modification application,
Lordship.
Lordship.
Lordships, we have two things to mention.